Few matters that need to be handled before we get started. Mr. Cruz, the court did not hear from you or anyone on your team yesterday, and you had said you were going to keep us posted. I sent out an email not only talking about court, but also needing the information for your WebEx witnesses, and we heard nothing, which was a bit unusual. Right. I just assumed Mr. Hill would respond since he's attorney of record also, and I don't even see him this morning, but I put him on the email too, so I thought he would communicate with the court.
I can't speak to Mr. Hill, but I know I didn't provide him any updates, so I take responsibility for that as well.
Okay. All right, thank you. All right, are you ready to proceed, Mr. Cruz?
I'd like to check and see if our witnesses.
Well, we got to get into some issues before we do that. So, all right. So the first few things are this. This gentleman sitting right here, I need to know, is this this young man an attorney?
No, Wilson is my law clerk.
Okay.
So this is my law clerk. This is my paralegal.
Okay.
They're in this case.
Okay.
These witnesses there.
Well, I understand that, but they are not allowed at the table during trial. So you're going to have to sit back on the benches. The other issue that I want to discuss, you both are going to have to sit on the benches. It is not allowed to have non-attorneys who haven't entered an appearance be at the trial counsel table.
Can't sit here either.
No, sir. They need to be back. The other thing is that one of the issues that I wanted to raise to make sure we're all on the same page, and this gentleman right here, I don't know your name, sir. I'm sorry. What's your last name? Evans. Evans? All right. Mr. Evans and Mr. Cruz, I know that you needed some information from Charlene Satterfield, who is our court reporter. You asked her when we were on a break, both of you at different times, for information for her to play back things from the record. That's not appropriate. We are in trial. If you need something from the record, it has to go through the court. And I want both of you to understand that it's definitely not acceptable for a paralegal to make a request like that at all. But it's definitely not appropriate for an attorney to do that without going on the record, either making a motion, asking the court, things of that nature. All right? Thank you. All right. I have the jury coming in later, and so this is the time for us to take up some other matters. We've just gotten the state's charges. Mr. Cruz is sending the charges to Ms. Ellis, so she's going to get those compiled. Counsel, what we typically do, and good morning, Mr. Hill.
Good morning, Judge.
What we typically do, and counsel for the state knows this, but counsel for the defense needs to understand this, is we will send you all a copy of the combined charges in one big document online. You'll get that on your email. So hopefully it'll be easy for you to look at it. When we do our charge conference, we'll print the entire thing out. Everybody will have a copy. We go through from front to back. So for Mr. Cruz and Mr. Hill, on jury charges, I always include for the court's charges the standard charges that every superior court uses in every criminal trial. And so all of the definitions, for example, for reasonable doubt, for just as an example, evidence, the burden on the state and things of that nature are always included. You certainly can include those in your charges. If you don't agree with how the court does its typical charges, we'll certainly consider whatever you present. But I just want you to know, if you want to bypass the typical charges that are involved in every criminal trial, you certainly can do so and focus on the charges that are in the indictment. So that's kind of our process. I don't know when we're going to get to that, but I want to make sure you all know that it's going to be a big document for you to look over, and we sort of go through it page by page. All right. Let me ask the state, are there any other issues the state needs to bring up? I want to talk to Mr. Cruz about his timeline in just a second.
Your Honor, we'll have a couple of different motions in limine that we would ask the court to consider this morning prior to witnesses taking the witness.
Okay.
Whenever you would like to do that.
Mr. Cruz, I'll hear from you in terms of your witnesses. We're going to need certainly the information for your WebEx people. And so I'll hear from you in terms of your witnesses, how long you think this is going to take. You may not know. But if you have any idea of where we're going, certainly.
I think we'll be done by noon. I still have to talk with the team to figure out exactly what order we're going to put individuals in.
Okay.
As far as the WebEx information, I can provide that to the Honorable Court now. If
Okay. We're gonna get, it's one of the reasons why I have the jury coming in a little bit later this morning is we need to get that set up.
Yes, ma'am.
Because I didn't have that information yesterday. So if you can actually send that by email right now to Ms. Ellis, we're going to get that to Ms. Craig, who is in the other county. She's in Oconee County, helping to handle court out there, and we will get her to set it up.
And I need to call her. She's not local. I advised the Honorable Court of that, so I need to call her just to let her know that.
When we're ready to roll? Sure, absolutely. But if you'll send the emails where we need to send the WebEx, I think we'll put both of them on for the same time. Well, I don't know if we should do that. Let me think. Let me ask you this, Mr. Cruz. Do you already know the order of those witnesses? Which one's going to go first?
I don't. I need to speak.
Okay, all right. I'll let you do that. Do that and let me know. I think I'm just sort of thinking out loud. I think that's better for the WebEx, that we'll try to do it in the order that you're going to call them, so they're not both on the same WebEx at the same time.
Okay.
Yeah.
Wait till the motion in limines because that may
Okay,
change.
sure. All right, very good. Any motions you want to present, Mr. Yalamanchi?
Yes, Your Honor, thank you. My understanding is, at least in part, we're not sure who all of the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Saudi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with the Athens-Clarke County Police Department. In part, he interviewed individual by the name of, Stephen Balden, who was a law student at the time, and he also interviewed an individual by the name, I believe, of Anthony Little, who was a resident of Athens-Clarke County at the time. These individuals were interviewed as initial persons of interest, but no evidence was ever developed to link them to the crime. And therefore, in addition, Mr. Cruz hasn't provided notice through in response to the state's Saudi motion, so no evidence of anything related to those two individuals would be relevant, and under a 403 analysis would be confusing and misleading to the jury. So we would make that motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records, and no notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a methods of questioning these witnesses or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or, even if they're not admitted into evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor, and I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call. If I could have just a moment to consult with Mr. Balden.
You can, but you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall, is that right?
Sergeant Tyndall and Mr. Newton.
Oh, and Mr. Newton, okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation laid for their admission, and then they could not subsequently be used in the manner that Mr. Cruz was attempting to use them, basically making a motion in limine to continue to adhere to the court's earlier ruling and prevent that process from playing out in the exact same way again. And then it's a similar argument with Sergeant Tyndall, because I think that those two witnesses are similarly situated as it relates to the phone records and their inability to testify to foundation for admissibility of those records.
All right, thank you. And you may have a moment with Mr. Balden, and then I'll hear from you, Mr. Cruz.
Okay. Your Honor, Mr. Balden will be making a motion in limine as well.
All right.
Good morning, Your Honor.
Good morning.
Yes, Your Honor, just to kind of piggyback on what Mr. Yalamanchi was just discussing, this is specifically as it would relate to John Newton's testimony. One of the things that the state expects that the defense may try to elicit through its direct examination of Mr. Newton is the fact that he had a conversation on January the 25th of 2001 with an individual by the name of Jessica Gann. That's G-A-N-N. Miss Gann, I believe, well, what's in the report is that she called and spoke with then Detective Newton on that date, on the 25th of 2001, January the 25th of 2001, that she was at Mexicalei Grill over on the east side near Kroger, and she heard some girls in the bathroom talking about law school. They appeared to be drunk. This was at about 9:30, and she thought one of them may have been Miss Baker. I think Mr. Cruz actually referenced that in his opening statement. The state would move to exclude any testimony by Mr. Newton as it relates to his conversation with Ms. Gann. First of all, it would be hearsay. And second of all, even if there were an argument that it is not hearsay, and I think that frankly the analysis should end there, but even if the court were to find that it is not hearsay or it is an exception to hearsay, at this point we would object on grounds under 401 and 403. It's not relevant, and any conceivable relevance is substantially outweighed by the risk of confusing the issues and misleading the jury. And in that regard, I would point out that the uncontroverted evidence at this point in the form of the testimony of Ms. Lonstein last week was that Ms. Baker was in the law school library until at least 9:46 when Ms. Baker called her to make sure she got home safely. And so the idea that she could somehow simultaneously be at a Mexican restaurant on the east side under the influence of alcohol is just not borne out by the facts. So the state would object to any testimony, any attempt to elicit testimony from Mr. Newton regarding that conversation.
All right, thank you. Anything else?
No, Your Honor.
All right, Mr. Cruz, several motions on the table. Go ahead, sir.
The only two that I'll address is first I'll start with, and good morning.
Good morning.
Board. First I'll start with Stephen Balden. I do intend to introduce that evidence, Your Honor, and not for the purposes of showing him as an alternative suspect, but for the purposes of showing that they had Mr. Chris Melton and this evidence leading to Mr. Chris Melton. And instead of executing a search warrant on Mr. Melton, the investigators decided to terrorize Mr. Barton and execute a full-blown search warrant on his house, obviously because he had nothing to do with Ms. Baker's murder, turning up no evidence of her murder. But these same actions were not taken with Mr. Melton. So the sole purpose of that testimony would be simply to, as we stated in opening, as we've maintained this entire trial, just to show that this investigation was not thorough. It was directed away from Mr. Melton at every twist or turn. In regards to Mr. Newton's testimony, in regards to Jessica Gann, as far as hearsay, we're not offering Jessica Gann's statements for the sole purpose of the truth of the matter asserted. Similar to the questions we asked about Ms. Keshana Armstrong, we're offering the information about Ms. Gann, again, to show that the investigation was not thorough, the early investigation. Law enforcement was aware of this information. They did not provide Ms. Gann with a photograph of Ms. Baker. They did not do any type of, I don't want to say a lineup, but they did nothing to follow up on the information with Ms. Gann. They got the information, they just ignored it and moved on. And that information also impeaches the state's position. The state's position is simply that because Mr. Faust's DNA is present, that means he's responsible for every single count in the indictment. One piece of evidence they have not shown, they haven't presented anything showing where Ms. Baker was the night before her death outside of the library. And in regards to the timepiece, I think that's more appropriate for cross-examination as opposed to a motion to limine. And the reason why, Your Honor, is the state has defended multiple witnesses on their time discrepancies, even time discrepancies that occurred closer to the crime. I believe Ms. Gann might have been interviewed, I believe it was 7 days after. So if she wanted to give and I believe the state made this argument in regards to a particular witness. I can't remember the witness. But if she wants to make an approximate time, hey, I believe it was 9:30, maybe 10 o'clock. I don't know what she said because we only have the report, but I believe it was around 9:30. That's something they could flesh out with Detective Newton during cross-examination, Your Honor. So those are the only two motion to limines we would seek to address with the Honorable Court. In regards to the phone records, the Honorable Court knows my position with the records. I respect the Honorable Court's ruling. I think you've made it clear that we are not to present any phone records of anybody at any time. So that's an issue that the Honorable Court has already ruled in the state's favor on. So we disagree, but we follow the Honorable Court's ruling.
All right, thank you, Mr. Cruz. I'll start with the phone records. The issue with the phone records was not necessarily a blanket instruction to prohibit testimony of phone records. The ruling was based on the lack of defense counsel's, for whatever reason, lack of providing the proper witnesses to bring those phone records in. And without the proper witnesses subpoenaed by the state, phone records are not allowed under law. And so that's the ruling I made. I want to make it clear for the record that the court's ruling was not a blanket. The defense cannot bring in phone records. Certainly, there might have been, if you had subpoenaed the proper people to bring them in, we could have had another hearing as to whether they were relevant. I mean, I'm not making a comment that they would necessarily be admissible, but just the ability to talk about them is based on the lack of ability to produce the proper foundation. I know we argued that at the bench, but I want to make that clear.
Can I respond to that?
You may.
The state, we had a hearing on this. I asked for out-of-state subpoenas regarding the phone records. I advised the Honorable Court at that hearing that Sprint, and I believe, I can't think of the other company, but the companies were out of business. They sent me emails stating that because the records were so old, they did not have a way to verify those records. The state explained to the Honorable Court that they would I'm looking for the proper word, but I don't have it now, so I'll just say they would agree to that for foundation purposes, the records are admissible. They said they would object on hearsay grounds, things of that nature. But our argument was that the records aren't hearsay because they are computer-generated records as opposed to a statement by a person, just to put that information on.
Well, let's talk about that because we did have a hearing with regard to those issues. There are a lot of phone records that we were sort of talking about at the time.
Right.
So let the state respond. We can talk about that. Go ahead.
I'll be happy to respond, Your Honor. That hearing did occur. At that time, we had been in for several weeks, I believe, attempting to discuss and lock down stipulations with Mr. Cruz, and it was the state's belief at that time that we were going to be in a position where Mr. Cruz was agreeing to stipulate as to the foundation for certain crime lab reports, and in exchange the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether or not we had stipulations. I drafted a list of proposed stipulations and I gave them to Mr. Cruz in the form of a physical document, I believe on the first day of jury selection. After reviewing that document and consulting with Mr. Faust, Mr. Cruz informed the state that at Mr. Faust's direction, the defense was refusing to stipulate to anything. So an offer was made and denied by the defense. And at that point, there were no stipulations, and the state has endeavored to call the appropriate witnesses to admit the evidence that it intended to admit via stipulation, and was certainly something that was available to the defense as well. But as the court noted, for whatever reason, those witnesses haven't been present in order to lay the foundation. So that's the context in which stipulations were discussed and then refused by the defense.
All right, thank you. Anything further, Mr. Cruz, based on Mr. Yalamanchi's comment?
No, ma'am, that's accurate.
Okay.
We refused stipulation made by Mr. Yalamanchi. Correct.
All right, thank you, sir. So I think based on that, and I do remember certainly the hearing, I can go through and look at my notes. They aren't in front of me at the moment and the order that the court signed. But I would just say, I mean, I'm going to grant your motion with regard to the phone records, Mr. Yalamanchi. I think that is appropriate legally at this point. If a stipulation is not entered, as was announced in court that you all would be able to work that out, the court would have had to know that in order to specialize or set a special time, I should say, to hear the rest of your motion, Mr. Cruz, to decide whether your motion was appropriate and whether what you were asking for could be granted, and that hasn't been done. I can't do it certainly in the middle of trial. So I'm going to grant your motion with regard to the phone records. With regard to any testimony from Mr. Newton with regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes. I mean, they've objected on other grounds as well, but what about the hearsay?
It goes to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case. I think a big part of the state's case is that law enforcement had information that they just failed to follow up on that would have resolved this case 20 years ago. So it's just notice. This goes to notice that law enforcement was aware of this fact and they didn't follow up on it.
All right. Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court at all. I certainly would say that under 403 we are talking about confusion of the issues and misleading the jury. I think that's certainly a problem. But I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago, is that's a pretty spectacular statement. And in order to ask the court to admit those statements in lieu of that comment, the defense has to provide the court some evidence that that would in fact have been true. And without that evidence, that testimony that you are seeking to elicit certainly, I would say, falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order that there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you know, you certainly can respond to what I've said, and then we're going to kind of move on. But go ahead.
So two things. My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or it should not have been, and forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica Gann, this case would have been resolved. I believe I stated it the wrong way. What I was saying is if law enforcement would have followed up on all leads, this case would have been resolved. As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide a response to the Honorable Court's objection regarding confusing the issues for the jury.
You certainly can. I thought Mr. Balden did make a 403 argument, and that's fine. I'll let you respond regardless, but I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403, the court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Detective Newton wouldn't require a mini trial to determine facts of issue. It's simply a building block on the facts in this case that support our position. I don't think that one fact I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. We started last Monday, if I'm not mistaken. That one fact out of 10 days of evidence, I don't believe that will confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Ms. Baker. So that would be my response. I do not believe that one fact would confuse the jury, and I'm not sure. Did you say waste of time also?
I did not.
You said confusion of the issues and one more.
Misleading the jury.
And my argument would be the same. I don't, out of 10 days of testimony, and of course, the Honorable Court has all the wisdom, I don't believe that one fact would mislead the jury to making a decision in regards to the indicted charge where they say, you know, we have this fact, now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I asked the Honorable Court to reconsider its ruling under 403.
All right, thank you, Mr. Cruz. I mean, I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person, first of all, it certainly sounds like hearsay. I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are, but I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. It is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very significant moment of misleading the jury and confusion of the issues. And so under 403, I'm going to grant the motion as well that Mr. Balden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding contents of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear, though. I want to talk about this. Is there an objection from the state, let's do this right now, about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records?
And that's what I was, can I respond before this? He
Sure.
laid the foundation for the phone records.
Sure.
The court order he obtained via recognizing the phone records, via stating that
Right.
those phone,
Right.
that they didn't appear to be altered. So he laid the foundation
Sure.
for the records that he received.
I remember that. I have that in my notes. But let's just get this out now so we're not having any, problems
I
later.
do not believe that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his court order is not the proper foundation for admissibility of those phone records.
I understand.
And so that's what our objection is to the contents.
admissibility in the contents.
The fact that he did in fact seek a court order, that the phone records were provided, are things that I think are appropriate questions that can be answered. It's just that any contents of the phone records cannot be asked about without the appropriate foundation witnesses, as the court's already articulated.
All right, thank you. So I want to make sure, Mr. Cruz, do you have anything else you want to say about that or any questions for the court? I mean, I do think that's right. And Sergeant Lieutenant Tyndall has already testified, as you said, about those records. They are in my notes. Again, I don't have it in front of me, but was Newton? Yes, ma'am. Yes, ma'am. Sure. Got the microphone again.
Newton
Right.
was the officer.
It was Officer Newton?
I don't believe Tyndale has testified at this moment.
That's right. It was Officer Newton. Okay, so let me just make sure we're clear. And I do recall the testimony. It was Mr. Newton, former Officer Newton. Are you intending to ask Sergeant Tyndall about phone records as well, obtaining phone records?
I am only going to ask Sergeant Tyndall about things the Honorable Court permits. From what I understand right now, that is not permitted, so no, ma'am.
Well, that's why we're having this discussion. I mean, I think the question as to whether an officer in his or her investigation received phone records is certainly a permissible question. And I agree with the state's characterization of that as being admissible. I think it's the contents and the admissibility of what's in the records that's at issue. So let's
Correct.
just flesh this out now and make sure we're on the same page.
So the contents, that's what's important to us, because I think it will establish the nature of Mr. Melton and Ms. Baker's relationship up until the day before her death. If the Honorable Court's ruling is that we are not to get into the contents of the phone records, and of course we put our response to the state's hearsay objection in regards to the phone records, so I won't go into that, Your Honor. But if the Honorable Court is saying, hey, my ruling is that you cannot get into the contents, you cannot talk about the phone records with the witness, I won't get into that.
Okay. All right. Thank you, sir. All right. So I'm not changing my ruling unless I'm presented with some other piece of information that is appropriate for the court to change its position without the proper foundation to be laid with regard to the contents of the phone records. They're not admissible in terms of the content.
Well, I do want to say this just to make it clear for the record. The foundation was laid by Mr. Newton. I think the disagreement between me and the state is saying it's hearsay, and I'm saying that it's non-hearsay because they're computer-generated records. That's the only disagreement. And of course, the Honorable Court issued its order on that.
Sure.
I just wanted to make that information clear.
All right, thank you. So it doesn't overcome the hearsay because there does need to be a foundation laid in terms of the contents of the record. And so of the records. I'm not going to change my order on that. A foundation has to be laid. They are hearsay. And unless the witness is a custodian of those business records, can testify to them as would be required under law, I am going to rule that the contents are not admissible. The questions about whether an officer received phone records is an admissible question. Mr. Yalamanchi, did you want to add something before we finish this phone records conversation?
Just briefly, Your Honor, I'm sorry, I should have mentioned this before. We would, although it's perfectly fine as from the state's perspective for Mr. Cruz to ask about whether or not Sergeant Tyndall or Mr. Newton received phone records, we would say that any affidavits that were submitted by the law enforcement officers in order to receive the court orders to get the phone records and the court orders themselves, I don't think are admissible as evidence, as substantive evidence in the case. Just the questions are appropriate, but I don't think those documents, as far as the affidavit, would be admissible and would be able to be submitted to the jury.
Okay, and tell me why you don't think they're admissible. What would be your argument?
Well, Your Honor, those affidavits are within them going to necessarily contain some hearsay information since they are, the officer's statement and affidavits for purposes of receiving court orders orders or search warrants are not limited by the rules of hearsay when they're being submitted to the judge. Now, if there were certain portions of them that serve to contradict testimony that the witness gave about things they did or did not do, then they may be admissible for the limited purpose of impeachment on those issues. But just simply tendering a law enforcement officer's affidavit, I do believe would contain hearsay statements within it, and also contain, their opinions on certain things and various other things that wouldn't necessarily be admissible in the context of a trial before a jury, although they would be appropriate for the purpose of having obtained the court order to begin with.
All right, thank you. Mr. Cruz, you care to be heard on that?
No, ma'am.
All right. Then I think that's right. I mean, that's, I think, a correct statement of the law. I would say, however, in the same vein as questions about did you obtain phone records is an admissible question. I think certainly, and I'm not telling you how to do your examination, but if you chose to ask the officer, did you seek a search warrant for phone records, that is an admissible question. And unless you want to be heard on that, Mr. Yalamanchi, I want to make sure sort of we're clear that there are certain things you certainly can ask law enforcement about their investigation, and asking for a search warrant and did they go seek one is an appropriate question. I think the contents of what they received would probably not overcome a hearsay objection. If you feel otherwise at the moment, we can take it up outside the presence of the jury. All right. With regard to Kishana Armstrong, or is it Keyshawn Armstrong? Kishana, all right. There was a motion in limine regarding any comment about another person with a name. Was it Scott? Was that? Hold on just a minute. Let me make sure I've written this down right. Did you make the motion about Ms. Armstrong? Was that you, Mr.?
I don't believe the state has any motion in regards to Ms. Armstrong.
I wrote down Ms. Armstrong. I thought there was something about Mr. Another person who they did not. You didn't bring evidence. Balden, is that correct? Or Bolton?
I hope not.
I'm sorry. Was it Bolton?
Balden.
Balden, sorry. Balden. Okay. I'm not sure I wrote it down. And you were expecting that information to come through Ms. Armstrong's testimony?
Well, no, Judge. It was Sergeant Tyndall.
That was Sergeant Tyndall. Okay.
Yeah, it would be Mr. Barden, and then also an individual by the name of Anthony Little. Okay. These would be two people that were considered persons of interest at the time. Okay. However, no information was developed to link them to the crime, and it was our belief, or at least we thought it might be a possibility, that Mr. Cruz is attempting to elicit testimony regarding those individuals from Sergeant Tyndall or Mr. Newton. I mean, just our motion in limine has to do with those two individuals just being mentioned in any way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right, thank you. All right, I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information. That may be why I wrote it down. You have the information. Fantastic. All right. Mr. Cruz, do you care to respond any further with regard to the remainder of the state's motion in limine as it concerns any person by the name of Balden and Little, last names?
Balden and Little?
Balden and Little. They were just referring to two. Barden? I'm not going to get it right. Barden. Sorry. Barden.
I believe I put that information on the record for the Honorable Court, our position, that nothing changes from our position.
Okay. All right. Thank you. I'm going to grant your motion. It does violate the Sadi motion the court has granted in previous hearings and that we have been discussing throughout the course of this trial. And so I'm going to grant your motion. There will be no testimony about anybody by the last name of Barden and Little through Sergeant Tyndall or Mr. Newton. It would violate the court's previous ruling. So, all right.
Your Honor, I hate to jump in on that. There was another piece of this that I think because Mr. Yalamanchi and I are kind of splitting up potential defense witnesses today, Mr. Newton also spoke with an individual at the Clark County Jail back in March of 2001. That person provided some other names of people who were allegedly making admissions or whatever about being involved in this crime. The inmate with whom Detective Newton at the time spoke. Her name is Melinda Thomas. The information she provided is secondhand hearsay about what some other people would have told her. These are not as it relates to Mr. Little or Mr. Balden, but under the same theory, the state would ask that any testimony about these other alternate perpetrators or potential alternate perpetrators also be excluded.
All right, thank you. Mr. Cruz.
Just for clarity, Your Honor, and I may have said it wrong or misspoken,
Okay.
but these individuals, I'm not saying they committed a crime. I understand the state's alternative perpetrator ruling. I'm not saying any of these individuals committed a crime. So I may have explained it wrong. The purpose of Steve Balden is to show the investigative steps. It has nothing. Our position is firm. Chris Melton committed this crime. We're not saying anybody else committed it. So if I say something that sounds like I'm saying, Judge, we want to point the finger at this person, we want to point the finger at that person, I'm just misstating. That is not what I'm saying. Anything that we're seeking to bring in at this point in our case in chief is to show the failures of the investigation. They have nothing to do with whether a person committed a crime. They have nothing to do with hearsay. It's just whether, did you have notice of this fact? Did you follow up on this fact? If not, why?
Okay.
That's our entire theory with the witnesses. As far as the witness Mr. Balden is speaking about, I just want to make sure we're talking about the same witness. May I see because there is one I wanted to discuss with.
All right.
Mr. So I, in fact, do intend to speak about Ms. Thomas. I wasn't going to refer to her by name. I was just going to say, did he speak to an inmate? And the purpose of this testimony is just to show, and I'll put it this way. It would be in sur rebuttal if the state has a rebuttal to our defense. So we wouldn't get into that information with Mr. Newton in our case in chief, but if there's rebuttal, this testimony will become relevant as sur rebuttal, depending on what the state's rebuttal is. So I would ask the Honorable Court not to make a ruling at this time until defense rests and the state lets us know if they are going to have rebuttal evidence in regards to the evidence that we present.
Okay. I'm not really sure I understand what you're asking, Mr. Cruz,
Sure.
about the rebuttal evidence, but I do want to respond to your arguments that relate to the state's. I'm actually looking for the order that I wrote with regard to this whole issue. Your responses to the state's motion in limine with regard to Mr. Balden, Mr. Little, this unknown person at the jail.
We don't have anything from Mr. Little. We didn't intend to elicit any
Okay.
testimony about Mr. Little.
Okay. But I'm going to mention this person in general because they all relate to the same thing. I understand certainly what the defense is saying about their position that the state law enforcement did not investigate this case properly. And I understand what you're saying about notice and that is those positions are the reason that the statements about other persons should be properly admitted. I understand what you're saying. The problem with that legally is this. The defense is asking for the court to allow it to go to admit those statements under that theory, and in doing so, that would bypass the court's order that it has already granted the state, which is that if there were any alternative suspects that were to be discussed at trial properly, the defense had to provide the proper notice, which would then allow the court to set a hearing so that we can determine whether the statements being offered about alternative suspects are admissible for lots of reasons, whether they would be admissible with regard to a hearsay objection, particularly whether they would be admissible because of relevance. And so just by stating, well, we're asking to admit those statements under a different theory, it is not appropriate for the court to allow that, because what that does is circumvent the prior order. They have to be done in conjunction. And so if the defense wanted to elicit testimony about other suspects for the purpose that you're asking for them to be elicited, notice under the Saudi motion we've been talking about had to have been done in order for the court to have heard in order for the state to have gotten the required notice, and in order for the state to have, the court to have set a hearing date in order to flesh this out, and that hasn't been done. And so I understand what you're saying, but it is not appropriate to circumvent the order by saying, well, it's just under another theory. That motion was not filed by the defense for whatever reason, and I'm not commenting on that. That may certainly be a strategic moment on the defense's part, but it hasn't been done. And because the proper notice hasn't been done, in order for the court to make a ruling that regardless of the state's feelings about those statements, regardless of any other legal objection that we've discussed in those hearings, those statements would be proper. The court hasn't had that opportunity because notice wasn't filed. So I'm going to grant the state's motion based on those for those reasons. All right, but I wanted to kind of make that clear. All right. Let me start again with the state. Anything else we need to take up before the jury comes back in?
No, Your Honor.
Okay. Mr. Cruz, is there anything else we need to talk about before?
Well, based on the rulings, I would like 10 minutes to talk with everybody because we have to figure out what.
Absolutely. So I think what we're going to do is this. We have your information for WebEx. We're going to go ahead and just get that set up. I'm going to give you all till 10:20. All right, so that's about 25 minutes. I'll be back on the bench at 10:20, and then we'll get started. All right, we'll be in recess until then. Thank you.
Your Honor.
Yes.
We need to speak with Mr. Faust too, so he'll need to be a part of that discussion. Can we make that happen? Mr. Faust would need to be a part of that discussion as well.
He can absolutely. He can remain here. No problem.